we give you...
We'll try that, Manoj. We'll try that. No issue, Manoj. We'll certainly try and speed it up. I mean, I just think, Manoj, your lordships may have questions yourselves.
Of course. If we find that, of course, there's a little change in the time schedule, we can certainly do
Then, Manoj, your lordships will also have to decide on the Nabam reference at some stage, what your lordship wants to do, because that sort of opens up another...
So we'll look at the list of dates?
Yes, Manoj. So on 1966, Shiv Sena, founded by Uddhav Thackerey, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Uddhav Thackerey was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Uddhav Thackerey, Uddhav Thackerey was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackerey unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the Act is to ensure that there are no unprincipled defections. Well, there is an elected government. The attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, Malaj, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Malaj, please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, your lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party, that is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to your lordships, now there's no question of majority, minority, 1/3, 2/3, not relevant, if there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, Malaj, 23rd of January, organizational elections of the Shiv Sena political party for term 2018 to 23 were held. wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordship, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it at all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, let's, October 2019, elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Aghadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, mullahs, have been conducting themselves. How can a governor have sworn in somebody as the chief minister without knowing that he has majority? In early hours of the morning.
This order is on 23rd November?
Yes.
Supreme Court's order?
Yes. Oh, the order, I just... 2019, 10 SCC, 809.
Tell me later.
Yes. Then, it's mentioned. Anyway, April, May 2020, governor has been at loggerheads with the MP. 25/11. Oh, 25/11, Sunil Prabhu. Now, this is important. 25/11, Sunil Prabhu is appointed as chief whip of the Shiv Sena Legislative Party with the blessings of Uddhav Thackeray, president of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordship, may actually, if Your Lordship don't mind, look at that document. Or do you want to read the dates and then later?
Please read the entire dates.
All right. Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thackeray's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat for in the legislative council which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So that these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the Cabinet Minister of Urban Development and Public Works, has along with certain others delinquent MLAs of the Shiv Sena gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21/6, these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena legislative party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which your lordships has to constitutionally consider. So a faction which is a legislative party decides that I will change the whip. Constitutionally impermissible. Then, my lords, the decision, then was Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackerey to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, because, as your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, in the meantime, somebody had to be appointed, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that court failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party.